Welcome back to Car Accident Playbook. I'm Alexis, and today I am here with Lem Garcia from Lem Garcia Law. Good to have you back, Lem. Thanks for being here today.
Thanks for having me.
Awesome. So today we are talking about how to file a car accident claim in West Covina, California, between the rush hour traffic on the I-10, the commuter flow on the SR-60, and the I-605, the freight and delivery vehicles cutting through the San Gabriel Valley every day. Car accidents here have their own pattern, and California's claim rules have their own quirks. We are going to walk through what to do at the scene, how the insurance system actually works, the deadlines that matter, and the most common mistakes that hurt a claim. Okay, now we're getting into the first question. What should someone do in the first hour after a car accident in West Covina to protect their claim?
The first hour after a car accident is critical. What you do early on can make or break your personal injury claim. First, call 911. Even after a minor car accident in West Covina, a police report creates an official record. That matters when the insurance company starts asking questions later. Second, get medical attention. A lot of people feel fine right after a crash because adrenaline kicks in fast. Then 2 days later, the neck pain, back pain, or headaches hit really hard. Early medical treatment helps protect both your health and your injury case. Third, take photos and videos of everything. Get the damage, the street, skid marks, traffic signs, and your injuries. Evidence disappears quickly after a car accident. Fourth, exchange information with the other driver, but keep it simple. Do not argue, do not admit fault, and definitely do not give a recorded statement to the insurance company right away. And finally, talk to a lawyer in California early on in your case. Insurance companies start building their defense immediately, and you should too. The sooner you protect your case, the stronger your position becomes.
Thank you so much for sharing. As we said, the first hour after a crash really sets the foundation for the entire claim, and most people have no idea what to do first. So thank you so much for sharing that. A lot of people skip the police call when nobody seems hurt or the damage looks minor. So why does calling 911 matter even after a minor fender bender in West Covina?
Because minor accidents become major disputes all the time. People think, oh, it's just a small crash. We can handle it ourselves. Then a week later, the other driver changes their story and the insurance company denies the claim completely. Calling 911 creates a very important piece of evidence for your case. That police report can help prove where the accident happened, who was involved, vehicle damage, witness information, and sometimes even fault. And that is huge in a California car accident claim. It also helps protect injured drivers. Some injuries do not show symptoms immediately. Whiplash, concussions, and soft tissue injuries can take hours or even days to appear. And here's the reality. Insurance companies look for gaps. If there's no police report, they might argue that the accident was not serious or never even happened the way you said it did. So even after a minor fender bender in West Covina, calling 911 is one of the smartest things you can do.
Thank you for sharing that. I know you kind of touched on this, but people walk away feeling fine and figure they skip the emergency room. Where should an injured driver in West Covina go for medical care after a crash, even if they feel fine?
You have to get checked out by a doctor immediately. That is the key. After a car accident, injured drivers should go to the emergency room, urgent care, or their primary doctor, or just a medical provider experienced in personal injury cases. The biggest mistake people make is waiting too long because they think the pain will go away. And here's the problem. Delayed treatment hurts both your recovery and your personal injury claim. Insurance companies love gaps in treatment. If you wait 2 weeks to see a doctor, they are going to argue that your injuries were not caused by the accident. And medically, some injuries are hidden early on. Concussions, herniated discs, whiplash, and internal injuries may not fully show symptoms right away. So even if you feel okay after a crash, get evaluated, protect your health first, protect your case second, and of course, both matter very much.
Most people have heard the words comparative negligence, but have no idea what California's version actually does. So how does California's pure comparative negligence rule affect what someone can recover after a West Covina accident?
This is very important for people to hear. Even if you were partly at fault for a car accident, you can still get paid for your injuries. That surprises a lot of people. And here's how it works. If you're found partially responsible, your recovery gets reduced by your percentage of fault. So if your case is worth, let's say, $100,000, but you were 25% at fault, you could still recover $75,000. People need to understand this. Insurance companies don't need you to lose completely. They just need you to lose a little. Blame you a little bit. That's why they look for anything they can use against you. Speeding, sudden braking, you were texting, you were changing the radio, anything really to put some of the blame on you. And in the California injury case, fault is everything. The stronger your evidence, the stronger your position. That's why after a car accident, photos, witnesses, dash cam footage, and medical records matter immediately. And one more thing, never assume you do not have a case just because you think you made a mistake. Some of the best cases start exactly there.
Wow. This is one of those deadlines that can end a case permanently if you miss it. So what is California's statute of limitations for a car accident injury claim, and what happens if you miss that deadline?
In California, you generally have 2 years from the date of the car accident to file a personal injury case. And if you miss that deadline, your case can be over completely. And I can't tell you how many times people have called to this office in a panic because they waited too long. And people wait because, they think, oh, the insurance company is treating me fairly, they're still getting treatment, or they think they have plenty of time. And then suddenly the deadline hits. And once that statute of limitation expires, it's game over. You might not be able to file suit at all, and they don't have to pay you anything. Here's what people in Southern California need to understand. Waiting hurts cases. Evidence disappears, witnesses forget details, and surveillance footage gets erased. And unfortunately, legal deadlines do not care how serious your injuries are. There are some exceptions, but they are few and far between. And that if a government vehicle is involved, deadlines can dramatically be shorter, typically 6 months to file a claim. And that's why speaking with a California personal injury lawyer early matters. The sooner you understand the timeline, the more protected your case is.
Most people have never heard of the SR1 until somebody mentions it after a crash. So what is the SR1 form, and what happens if a West Covina driver doesn't file it after a car accident?
That's exactly right. Most drivers have never heard of the SR1 form until it becomes a problem. The SR1 is a California DMV accident report that drivers are legally required to file after a car accident. Generally, you must file it if someone was injured, someone was killed, or property damage exceeds $1,000. And here's the mistake people make. They think the police report handles everything. It doesn't. The SR1 is separate from the police report, completely separate. In California, drivers usually have 10 days after the accident to file the SR1 with the DMV. If you fail to do it, your driver's license can actually be suspended. That catches people off guard all the time.
Wow. California has the lowest minimum coverage limits in the country, and most people don't realize how thin that coverage really is. So what does California's 30-60-15 minimum auto insurance coverage actually pay for, and why is it usually not enough?
Yeah, as of 2025, California raised the minimum insurance to 30-60-15, and that means $30,000 for injury to one person and $60,000 total per accident, and $15,000 for property damage. I mean, that sounds decent on paper, but in real life, that money disappears quickly. One ambulance ride, one emergency room visit, and one MRI after a serious car accident can burn through $30,000 quicker than people think. And then you add physical therapy, missed work, pain management, or surgery, and that the costs add up in a hurry. And here's the scary part. A lot of drivers in Southern California still carry only the minimum coverage because it's cheaper. So when a serious crash happens, there may not be enough insurance money available to fully pay you for your injuries. And that becomes a massive problem for accident victims, especially in a high-cost state like California. And the property damage side is not much better. $15,000 may not fully replace most of the newer vehicles on the road today. And that's why it's so important to have uninsured and underinsured motorist coverage, because the person who hits you may technically be insured, but they probably don't have enough insurance coverage. That's a very, very unfortunate reality that people do not find out until after the accident.
Makes sense. Once someone has been to the doctor, documented everything, they need to figure out the insurance side. Walk me through the step-by-step process of filing a California car accident claim after a West Covina crash.
First, report the accident and get medical treatment immediately. Not next week, not when the pain gets worse, but immediately. Because one of the first things insurance companies look at is timing. Second, document everything: photos, videos, witness information, police reports, medical visits, and vehicle damage. The strongest California car accident cases are usually the best documented ones. Third, speak with a California personal injury lawyer early, even if the accident seems minor at first. A lot of people underestimate injuries early. They think it's just soreness, and then the pain gets worse a day later. Meanwhile, the insurance company already started evaluating the claim. That's why early guidance matters. Once mistakes happen, delayed treatment, recorded statements, missing evidence, fixing them becomes much harder. Next, the insurance claim gets opened. That may involve your insurance company, the other driver's carrier, or both. And then treatment continues, and consistency matters. Insurance adjusters pay close attention to gaps in treatment. If care stops for weeks or months, they're going to argue that your injuries aren't serious. Then, several weeks later, the medical picture becomes clearer and the case gets valued. That may include medical bills, future treatment, lost income, pain and suffering, and how the injuries change daily life. And then negotiations begin. And that's where most people get frustrated. Insurance companies do not pay based on sympathy. They pay based on risk, documentation, and leverage. If the top offer is unfair, the next step may be filing a personal injury lawsuit. And honestly, the biggest mistake injured people make is waiting too long to protect the case. The best personal injury cases usually start early, stay organized, and build momentum from the beginning.
Thank you so much for sharing that. We have covered comparative negligence, the deadlines, the SR1, the 30, 60, 15 minimums, and the actual claim filing. Now let's get into the mistakes that kill claims. The adjuster calls and asks, "Do you mind if I record this for the file?" And most people say yes. Why should you never give the other driver's insurance company a recorded statement after a West Covina accident?
After a car accident, the other driver's insurance company usually calls really quickly, sometimes within hours. And the conversation sounds harmless. "Oh, just wanted to get your side. Oh, just need to clear up a few details." But that recorded statement is not designed to help your injury claim. It's designed to hurt your case. Right after an accident, most people are guessing. They don't know how fast the other car was going. They don't know whether adrenaline is masking pain. They don't know if that sore neck is going to turn into 6 months of treatment or not. But the insurance adjuster is still recording every single word. And later, those words get compared against your medical records. If you say, "I think I'm okay," then 2 days later you end up in urgent care, the insurance company will argue your injuries are exaggerated. Insurance companies don't need to prove you're lying. They just need enough doubt to reduce the payout. And that's why California personal injury lawyers tell clients not to give a recorded statement without legal advice first, especially after a Southern California car accident where even a small shift in blame can seriously reduce how much you get paid. One sentence can cost thousands of dollars.
Wow, it's actually so crazy. They're like actually trapping you. Like, that's wild. Most people don't realize the insurance company is watching. How do social media posts and surveillance hurt a California car accident claim?
Oh, don't even get me started on this one. Somebody will post a selfie in front of a red car smiling like they just finished a 5K. If people just stayed off social media after accidents, I'd probably be retired already. But honestly, social media has probably saved insurance companies so much money. I wouldn't be surprised if they're in on it with the social media companies. But anyways, I think it's really important that people do not post anything on social media after a car accident. The insurance companies are most likely watching. They're gathering all the information to hurt your case. So just stay off of social media. Don't post anything, and just wait until your case is resolved to make any posts on social media.
The demand letter is the heart of the negotiation, and timing matters. What is a demand letter in a California car accident claim, and when should it go out?
A demand letter is the document that your lawyer sends to the insurance company explaining what happened, how serious the injuries are, and demanding how much money they need to pay to make this case against their insured go away. Think of it as the first serious settlement conversation. A strong demand package usually includes medical records, medical bills, lost wages, photos, evidence from the crash, and documentation showing how the injuries affected daily life. But timing matters. One of the biggest mistakes people make after a car accident is trying to settle too early. At first, injuries can seem manageable, then the MRI comes back, the injections start, the physical therapy keeps going, and now the case looks very different. And once you settle an injury claim, you usually cannot reopen it later. That money is final. So it might sound reasonable on paper, but in real life, maybe not so much. So make sure that you wait until you have your injuries fully documented before a demand letter is sent out.
Most people assume it is just the car repair and the medical bills. So what type of damages can someone recover after a West Covina car accident?
After an accident, an injured person may be able to recover several types of damages. And the first are economic damages. Those are the financial losses tied directly to the accident. Things like emergency room bills, surgery costs, physical therapy, lost income, future medical treatment, property damage, and for your reduced ability to work. Those damages usually come with receipts, records, and numbers. Then there are non-economic damages. That's pain and suffering, emotional distress, anxiety, loss of enjoyment of life. And honestly, those damages are often the hardest for insurance companies to measure fairly. Because how do you put a number on not sleeping for 6 months? And how do you measure the stress of chronic pain or not being able to pick up your child the same way anymore? That's the part insurance companies fight hard. And in some cases, punitive damages may also apply, especially in drunk driving cases or extreme reckless driving situations. But those types of cases are far less common. The bigger issue in most car accident claims is making sure the full impact of the injury is actually documented. Because if it's not documented, the insurance company acts like it never happened.
Interesting. This is where settlements get won or lost. How are pain and suffering damages calculated in California?
Pain and suffering damages in California are subjective. There's no fixed formula, no universal chart. Insurance companies look at several factors: how severe the injury is, how long recovery takes, whether the condition is permanent, how much treatment was needed, and how the injury changed everyday life. And medical records matter a lot here. And so does consistency. If someone waits 3 months to see a doctor after a car accident, the insurance company is going to question the injury claim immediately. That doesn't mean the person is lying, but it does mean the case becomes harder to prove. And proof matters. Pain and suffering damages are not just about pain. They're about loss of movement, loss of sleep, loss of independence, loss of normal life. And a strong personal injury lawyer builds that part of the case carefully through medical evidence, treatment history, daily limitations, sometimes testimony from family members or doctors, because pain is invisible. And if you do not document invisible injuries properly, the insurance company will often pretend that they do not exist.
So we have covered the common mistakes, the recorded statement trap, social media risks, demand letters, and damages math. Now let's talk about California's specific protections and when to bring in a lawyer. Most people have never heard of Brandt fees, but they can change the entire negotiation. What is California's Brandt Rule, and how does it punish insurance bad faith?
California's Brandt Rule basically says this: if an insurance company acts in bad faith and forces you to hire a lawyer to recover benefits you were supposed to receive, the insurance company may have to pay those attorney's fees. And that matters more than people realize, because insurance companies know financial pressure changes behavior. They know accident victims have medical bills, missed work, stress, and uncertainty. So sometimes the strategy is delay. Delay the payment, delay the investigation, delay the response, and hope the person gets desperate enough to settle for less. But California bad faith law can flip the pressure back onto the insurer. Now the delay starts costing them money too. That's where the Brandt Rule becomes powerful. And here's the important distinction. This usually applies in disputes involving your own insurance company. So when they collect premiums for years and disappear the moment someone actually needs help, California law takes that seriously.
What happens to a California car accident claim if a government vehicle was involved? This is a deadline that is much shorter than the standard 2-year clock. So what happens to a California car accident claim if a government vehicle was involved?
When a government vehicle is involved in a California car accident, the rules change immediately. And the biggest mistake people make is assuming it works like a normal injury claim. It does not. If the accident involved a police vehicle, city truck, county bus, sanitation vehicle, or any other government agency, you usually have to file a government claim first before you can even file a lawsuit. And the deadline is much shorter. In most California personal injury cases, you generally have 2 years to file suit. And against a government entity, usually 6 months to file the claim. And that deadline hits fast, especially when someone is still dealing with medical treatment, vehicle damage, and insurance issues after a Southern California car accident. And government agencies defend these cases aggressively from day one. There may also be immunity defenses that do not exist in ordinary car accident claims, meaning even proving fault can become more difficult. And that's why timing matters so much here, because in government claims, a missed deadline can destroy a valid case before the insurance fight even starts.
Wow. A lot of people are not sure if their case is even big enough to justify calling a lawyer. So when should a West Covina accident victim hire a personal injury attorney instead of handling the claim alone?
Honestly, it depends on the situation. After a car accident, it usually makes sense to at least speak with a personal injury lawyer early. Consultations are free. And here's the funny part. Who is the only person that can really tell you whether you need a personal injury lawyer? A personal injury lawyer. Because a lot of people think, I'll wait and see what the insurance company says. It sounds reasonable, but meanwhile, the insurance company already opened its file and started evaluating the claim. They're reviewing records, taking statements, looking for treatment gaps, checking social media, and figuring out how little they think the case can be resolved for. That process starts earlier than most people realize. And once mistakes happen, fixing them gets harder. Maybe a recorded statement was given too early, maybe treatment was delayed, maybe important evidence disappeared. Now the value of the injury claim starts dropping before negotiations even begin. Insurance companies handle claims every single day. Most injured people have never been through a serious accident before, and that experience gap matters. A good car accident lawyer is not just there to file paperwork. The job is to protect the case before the insurance company starts defining the story first. Because once the insurance company controls the narrative, they usually control the leverage too.
Absolutely. This is a situation nobody expects to be in. What if the at-fault driver is uninsured, underinsured, or fled the scene of a West Covina accident?
A lot of people assume they're out of luck if the other driver has no insurance or disappears after a crash. That's usually not true. In California, your own insurance policy may still provide coverage through uninsured motorist or underinsured motorist protection. That coverage can help pay for medical bills, lost income, and pain and suffering. And here's the part most people don't realize. Insurance companies don't suddenly become generous just because it's your own policy. They still look for ways to reduce the injury claim. If the driver fled the scene, timing matters. Fast investigation can help identify witnesses, surveillance footage, vehicle debris, or nearby cameras before evidence disappears. And if the driver had minimal coverage, an experienced personal injury lawyer can look for additional sources of recovery. That can include employer liability, commercial insurance policies, rideshare coverage, or other responsible parties. And it sounds straightforward on paper, but these cases can get complicated really quickly. And that's why speaking with a car accident lawyer early matters, especially after a hit and run or an uninsured driver accident. Because the biggest mistake people make is assuming there's no case before they actually know their options.
Well, now that we have covered Brandt fees, government claims, when to hire a lawyer, contingency fees, and uninsured drivers, let's wrap up with the evidence, lien, and litigation pieces that round out the picture. Medical liens can take a serious bite out of the settlement check. What is a medical lien and why does it matter in a California settlement?
A medical lien allows an injured person to get treatment now and pay the provider later from the settlement. And that matters after a car accident because many people are dealing with missed work, medical bills, and an insurance company at the same time. But not every lien works in the client's favor. Some are reasonable, and some can take a serious bite out of the final recovery. And that's why a good personal injury lawyer looks beyond the settlement number itself. The real question is how much compensation the client actually keeps after medical bills, liens, and costs are resolved. Because a settlement can sound substantial at first, then the deductions start showing up.
Beyond the basics, there's a lot of evidence that tips the scale. What types of evidence make or break a California car accident case?
The strongest car accident cases are usually the ones where the evidence tells one clear story. Photos help, witnesses help, medical records matter, but consistency is what insurance companies pay attention to. If treatment is delayed, they notice. If the injuries aren't documented clearly, they notice that too. Insurance companies don't need to erase an injury claim completely. They just need enough uncertainty to lower the value of the case. That's why early treatment, scene photos, dash cam footage, surveillance video, and accurate medical records can make a major difference in a personal injury case. A strong car accident lawyer starts protecting the case early before the insurance company starts protecting its position.
When the offer is too low, filing a lawsuit becomes the next move. When is a personal injury case worth filing a lawsuit in Los Angeles County Superior Court?
Not every injury claim needs a lawsuit, but when the insurance company refuses to make a fair offer, disputes liability, or minimizes serious injuries, filing a personal injury lawsuit may be the step that changes the case. Insurance companies pay attention when a case becomes expensive to ignore. Once a lawsuit is filed, there are depositions, expert witnesses, court deadlines, and real litigation exposure. Most cases still settle, but the conversation usually changes once the insurance company sees the injured person is prepared to push the case forward. And that's where an experienced California personal injury lawyer can make a major difference, because sometimes the value of a case changes the moment the insurance company realizes the case is actually being taken to court.
We've covered evidence, liens, and litigation pivot. Let's close with the most important things to do right now. For someone listening right now who has just been in a car accident in West Covina, what is the one thing you want them to remember?
If there's one thing I'd want people in West Covina and across Southern California to remember, it's this. Don't assume the insurance company is going to do the right thing just because the accident wasn't your fault. The biggest mistake in personal injury cases usually happen early when people are hurt, stressed, and trusting the insurance company to be helpful. And that's when important evidence disappears. That's when people delay treatment, and that's when insurance companies start building their side of the case. At Lem Garcia Law, we help injured people understand what their case may actually be worth, deal with the insurance company, and pursue the compensation California law allows. And we try to keep the process straightforward and honest, because most people calling a car accident lawyer are already dealing with enough stress. If you were injured in an accident and you have questions about your rights, your injuries, or a possible personal injury lawsuit, call Lem Garcia Law for a free consultation.
If you've been in a car accident in West Covina and you're not sure what to do next, make that call. You can find Lem Garcia Law at lemgarcialaw.com or call them directly at 626-337-1111. Thank you so much for watching, and we will see you on the next episode of Car Accident Playbook.